All rise. The African Court of Justice and Human and People's Rights is now in session. Judge President Doris, presiding together with Honorable Judges Mr. Patrick and Ms. Farida Bundi. The matter before the court is the situation. All rise. The African Court of Justice and Human and People's Rights is now in session. The matter before the court is the situation in Uzuri. The parties are the Office of the Prosecution versus the defense, Ms. Lushomo Ngala. Each party has been allocated 35 minutes of the court's time. Madam President, over to you.
Good afternoon, everyone. I think the judges can introduce themselves, and then we can proceed. So my name is Doris Kompati. I'm from Kenya.
Your Honor, may we proceed?
Yes.
May it please the court. My name is Kadus Yarid, and I will be presenting the case of the prosecution against Ms. Lushomo Ngala, along with my co-counsel, Mr. Agitinat. The case of the prosecution versus Ms. Lushomo Ngala concerns a warmonger who not only aided an invader in unlawfully detaining persons protected under international humanitarian law, but also an aider and instigator of unwarranted attacks against protected persons and property. Before elucidating this statement, I will present arguments regarding the admissibility of the case before this honorable court, and then explain that for the purposes of this case, Uzuri must be considered Saliman territory. After that, I will proceed to the third issue, that is that the war crime of unlawful confinement was intentionally committed in Uzuri. I will then elucidate Ms. Lushomo's individual criminal responsibility as regards this war crime. Finally, I will argue that count 2 and 3 of the alleged war crimes were committed in the context of an international armed conflict, after which my co-counsel will argue that the remaining counts of war crimes have been intentionally committed and the individual criminal responsibility of the accused thereto. Now, regarding admissibility, according to its establishing protocols, this criminal court's jurisdiction is complementary. According to Article 46H of the Malabo Protocol, it can only be exercised when, among other requirements, national courts with first instance jurisdiction are either unwilling or unable to deal with a case. It is abundantly clear that Bukada's national courts had jurisdiction over the matter, since the accused, Ms. Lushomo, is a national of Bukada. However, as seen under paragraph 28, line 10 of the agreed facts, Bukada not only refused to prosecute Ms. Lushomo and in the alternative to extradite her, but also refused to investigate her entirely. It is the contention of the prosecution that Bukada's behavior as regards Ms. Lushomo is motivated by its unwillingness to bring the accused to justice. This unwillingness is in turn established by considering Article 46H, subarticles 3 of the Malabo Protocol, which says, among others, that a state is considered unwilling when it has chosen not to investigate or prosecute for the purpose of shielding the accused. Your Excellencies, it can be seen that Bukada had the intention of shielding Ms. Lushomo, and for several reasons. For one, if Bukada prosecutes Ms. Lushomo, it will also inevitably expose the state's responsibility for failing to ensure that international humanitarian law is respected. This is an obligation seen under Common Article 1 of the Geneva Conventions and reiterated in the Montreux document, which says that home states, that is, states where a private military and security company is incorporated, have an obligation to take appropriate measures to prevent and suppress violations of international humanitarian law. Bukada didn't sanction Ms. Lushomo when she aided the aggression of Kedi Bonye, and as a state would be responsible for its inaction to do so. Secondly, the accused's company, Asai Roma, is incorporated in Bukada, as seen in paragraph 6, line 2 of the agreed facts. Companies normally pay taxes and fees where they're incorporated, and Bukada is most probably no different in this regard. It earns a significant amount of tax from Asai Roma, and if it does investigate and prosecute Ms. Lushomo, it will indubitably have grave effects on the relations between the company and Bukada, and introduce a possibility of this stream of tax money drying up. Hence, we submit to this honorable court that Bukada is clearly unwilling to look into the case of Ms. Lushomo. The other grounds for inadmissibility seen under Article 46H of the protocol haven't been fulfilled, as Ms. Lushomo was not tried previously and her acts are grave enough to justify further action by this court. I proceed to the first count of war crimes, and in doing so, it is provided for in various international humanitarian law instruments that for there to be the war crime of unlawful confinement, detentions contrary to the rules of international humanitarian law must be effected in the context of an armed conflict or a belligerent occupation. It is at this juncture that the prosecution submits that for the purpose of this case, the enclave of Yuzuri must be considered Saliman territory because residents of Yuzuri have voted to be part of Salima as seen under paragraph 2, line 5 of the agreed facts. Hence, as per the International Covenant on Civil and Political Rights, Article 1, their right to self-determination must be respected and Yuzuri must be considered Saliman territory. Further strengthening this claim is the principle of uti possidetis, which states that territory and boundary disputes must be resolved by taking into account the configuration prevailing at the time of independence. This principle was seen in the International Court of Justice's judgment in the case of Burkina Faso versus Mali. In marrying the law with the facts, when Kedibonye and Salima achieved independence, the colonial ruler, that is Bukada, recognized Salima's claim over Yuzuri, as seen under paragraph 2. For this reason, we contend that Yuzuri must be considered Saliman territory and urge the Honorable Court to make subsequent rulings by having due regard to this matter. Regarding to the war crime of unlawful confinement, we submit that Kedibonye had occupied Saliman territory. This is because the three cumulative requirements for there to be occupation have been fulfilled. The occupation was non-consensual because both Salima and Yuzuri are against the occupation, as seen under paragraph 4. The second requirement of ability to exercise authority has also been fulfilled since Kedibonye only installed a puppet government in the Yuzuri Reunification and Autonomy Party and could exercise authority if need be, which is the threshold sought by international humanitarian law for the fulfillment of this criterion. The third criterion was fulfilled when Kedibonye armed forces entered Yuzuri with a view to enforcing the occupation as seen under paragraph 9, line 3 of the agreed facts. The International Criminal Tribunal for the former Yugoslavia, in the case of Prosecutor versus Nalitilic, can be mentioned in this regard. The tribunal held that a less restrictive definition applies when the establishment of a state of occupation concerns protected persons. It further held that if the matter affects protected persons, the occupying power is not required to have actual authority. The prosecution submits that Kedibonye, using AFROT, arbitrarily detained Yuzuri residents under international humanitarian law. Occupying powers may detain protected persons only as a last resort. In addition, where detention is deemed necessary, a decision must be made according to a regular procedure on an individual basis. AFROPT was used to detain residents that expressed support to the Yuzuri Liberation Front, as seen under paragraph 11. Expressing support rarely indicates that an individual is a security threat. In the rare cases where support indeed indicates threat, the occupying power must ascertain and decide considering specific circumstances like the mode and content of the support. Most of the support was expressed through social media, and the content of the support wasn't menacing, as there were only statements defending the acts of the Yuzuri Liberation Front and protesters, as seen under paragraph 9. Supporters didn't threaten to attack Kedibonye, nor the Yuzuri Reunification and Autonomy Party. Those residents that posed security threats, Kedibonye could have identified individually and detained them in accordance with the regular procedure. Kedibonye had found social media messages that were used to organize protests. Not only this, Kedibonye had data from the Smart City Project and Asadat, which could have been used to identify threats on an individual basis. Kedibonye's detention of Yuzuri residents violated both the substantive and procedural rules of international humanitarian law. Further, as corroborated by the ruling of the International Criminal Tribunal for the former Yugoslavia and the case of Prosecutor versus Knojelak, elements of unlawful confinement were recognized, and they were that there must be arbitrary deprivation of liberty with the requisite intent of doing the same. Such detentions are considered unlawful confinement. which is a war crime. Now, as regards Ms. Lushomo's responsibility, we hold that Ms. Lushomo is individually criminally responsible as per Article 46B of the Malabo Protocol for the war crime of unlawful confinement. Through providing AFROPT to the Kedibonyi government, Ms. Lushomo aided the war crime of unlawful confinement, an act that is considered as commission of the offense as seen under Article 28, subarticle 2 of the Malabo Protocol, which is entitled Modes of Responsibility. Ms. Lushomo has extensive business dealings with Kedibonyi and Salima, and most probably knew of the predicament in Yuzuri. She must have heard the plans of Kedibonyi to arrest Yuzuri residents through various news outlets. One of these outlets, the Kedibonyi Herald, published the plans of Kedibonyi to detain Yuzuri residents as seen under paragraph 10 of the agreed facts. Ms. Lushomo also permanently resides in Salima, where the subsequent arrest of Yuzuri residents was widely covered in the media, as seen under paragraph 11. Her criminal intent is corroborated by the fact that even after it became apparent that AFROPT was being used to arbitrarily detain Yuzuri residents, she did not stop Kedibonyi from using AFROPT in Yuzuri. My final submission before my co-counsel takes over is that the war crimes to be presented by my co-counsel were committed in the context of an international armed conflict. As per Article 1, sub 4 of Additional Protocol 1, where peoples are fighting against alien occupation in the exercise of their rights of self-determination, that situation is considered an international armed conflict as regards signatories of Additional Protocol 1, which Kedibonyi is. The Yuzuri Liberation Front has the Yuzuri people's backing in its fight against the alien occupation of Kedibonyi. The other reason is that Salima directed the attack on Kedibonyi by the Yuzuri Liberation Front. Salima's weapon supply signaled the beginning of a coordinated and united attempt to reunify Yuzuri. Therefore, the conflict between the ULF and Kedibonyi is part of the war between Salima and Kedibonyi. For these reasons, the prosecution submits that the situation in Yuzuri from the beginning of early July 2022 was an international armed conflict. If I am not going to be of further assistance to this court, this concludes my submission. I thank the court.
Council, I have a couple of questions with regard to your submissions. The first question would be, you have stated that the matter is admissible before this court because Yuzuri was unwilling to prosecute. Is that correct?
Bukada was unwilling to prosecute.
Thank you. Quater was unwilling to prosecute, but are the actions of basically arresting this lady and bringing her to court, to this honorable court today, do those not amount to willingness to actually have her stand trial before a court of competent jurisdiction? And maybe because of the situation back home, the reasons why there's actually, because of the strike, there might be issues with the justice system. And that's why they probably needed more time to be able to get the justice system together and prosecute Ms. Ndala.
Well, in answering your question, I believe that the fact that Bukada detained and brought Ms. Lushomo to this honorable court does not indicate its willingness to prosecute and investigate her. Of course, it did not consider when it detained and brought her to this court. The Bukada did not affirm that it was willing to prosecute and investigate. It merely did so to, we can assume, to merely maintain international community and its international relations. Refusing to assist this court will have further implications in other relations. However, the mere fact that it had detained and brought her to this court does not show that it is unwilling to, does not show the fact that it is willing to prosecute.
My second question is, in this instance, you're trying to prosecute Ms. Ndala for her actions as an individual. but the programs that she developed and the technology that she came up with were used. You actually said it's an IAC, it's an international armed conflict, were used by a state against a state. So why not bring the state before court? Why specifically target only one person whose rather contribution is merely development?
Well, I believe we are of the opinion that Ms. Lushomo Wangala's contribution was not merely the supply of weapons. She was not a manufacturer, and she didn't only send these softwares. She followed up, and she had oversight over this matter. She could have refused, understanding that the Kedibone government's actions were visibly against international more manifestly against international humanitarian law. She didn't. She, in fact, provided, as will be subsequently presented by my co-counsel, when she provided the weapon bird target, she saw, in fact, when the bird target targets these civilians, targeted the civilians and inflicted the attack, those images were sent to Sayoroma servers, and that is after which the attacks were opened. Therefore, she knew, and in fact, it was in real time. These technologies require the follow-up of the manufacturers as opposed to mere guns, ammunitions. It is not a one-and-done situation. This perpetrator had oversight over the matter throughout in providing Abrupt, in providing bird targets, and in providing Adam throughout. She had control. She could have pulled back these weapons when it became apparent that Kedibone was using it for the commission of war crimes.
And so my last and follow-up question is, between the developer of an autonomous weapon and the general representing the state who says, okay, now you can target these people, or rather you can launch the attack, who should be held liable? Is it she who developed the software, or the actual person making a decision on where the attack should actually be held?
It is the opinion of the prosecution that both of these, the commander and the weapon supplier in this case, must both be held criminally liable. They are accomplices because, in fact, both of them have oversight. As I've said earlier, you have a question?
Sorry, on what law, and if there's case law also to back up your answer?
Yes, it is, of course, the knowledge and the intent that matters in this case. And of course, for the others, for the commanders, we can see that their responsibility is established under Article 46B, that superiors and subordinates are both responsible under the Malabo Protocol, of course. And of course, other individuals that are not related to the military operations, that are not military personnel per se, are included under Article 46B, sub-article 1 of the Malabo Protocol. Any individual could be held responsible provided that they have committed war crimes. And of course, what Ms. Lushomo knew, considering what Ms. Lushomo knew and her intent, it can be clearly seen that she was committing these war crimes when she aided Kedibone in its acts of aggression and in the commission of these war crimes.
Okay, thank you for your answer. I'm not sure whether other judges have questions.
Thank you very much.
Yes, I do. All right, thank you, Madam President. Councils, I believe you're here before this honorable court for a confirmation of charges against Ms. Lushomo Ngala. Kindly clarify to this court on the issue of admissibility in terms of complementarity and gravity of the offenses that you have.
Well, as I've previously said, the case is admissible before this court because the state with national jurisdiction, Quater, is unwilling to prosecute the accused. And of course, as regards gravity, it has been unequivocally and inarguably seen that through the weapons that Ms. Lushomo had provided, civilians had been killed. civilians had been detained, and protected property has been destroyed. It has been, this fact has been indisputably seen, and considering the nexus that Ms. Lushomo Ngala had with this case and her continued correspondence with the Kedibonian government, it is clearly seen that her acts were grave enough, that the war crimes are grave enough indeed, and that this case must be reviewed by this court, hence fulfilling both the admissibility requirement and subsequent to it, the gravity requirement that needs to be fulfilled under the Malabo Protocol.
Thank you, Madam President. Council, you have made reference to Article 46B, the Malabo Protocol. And indeed, of course, it establishes two elements that need to be proved in a cumulative manner, for the superior to be held responsible. Now, can you demonstrate before this honorable court that the superior did not in any form?
I beg your pardon, may you please repeat that last part of your question?
Can you demonstrate before the honorable court that the superior kneeled to prevent the acts or to punish the perpetrator?
I haven't gotten the question. The internet was, the connection was stuck.
Okay, the question is, you have made reference to Article 40B.
Yes.
There are two elements that needs to be proved. Now, I'm interested on the second element, that the superior did not prevent the atrocities from being committed.
As I've mentioned earlier.
Is that the position that, is it your position that the same was not done?
Yes, the same was not done. She did not take measures to avoid the commission of these crimes. Of course, the remaining two counts regarding protected persons and property are going to be presented by my co-counsel. However, as regards the count of unlawful confinement, as I've said earlier, we've established her knowledge by invoking the facts that these plans to detain Yuzuri residents were extensively reported in media outlets, both in Kediboni and in Salima. And the latter, of course, her failure to take measures to avoid the commission of these war crimes can be seen in that even after it became apparent that Afropt, the software that was used to unlawfully confine these residents, was used, it was made applicable in Yuzuri. She did not call back this software. This is a software and can be controlled remotely. By failing to pull the plug and to refuse Kediboni from using this software, her intent and of course her failure to avoid the commission of crime can be established.
Councillor, don't you think by virtue of making reference to paragraph 27 of the agreed facts, that indeed the superior tried to prevent, and if not, then what is the threshold of such prevention?
Well, I believe you are referring to Adam, the artificial intelligence drone that could attack in its own initiative. Of course, we must consider here that the fact that she said, she told her subordinates to pull back, to patch up this software is not enough. It has been seen, according to the attack against the Saint Eligius Church, it has been seen that this weapon is lethal. It is not developed enough to comply with international humanitarian law. Therefore, when she said to patch this software up and to return it to the battlefield, she was effectively accepting the adverse consequences that may materialize. And this indicates her intent. The prudent thing to do on her part would have been to call back this drone, would have been to cease its operations, which she could have done, because this remote controlled weapon can be called back by her company.
Okay, in this instance, I think all the questions are answered. We can move on to the second speaker.
Much obliged, Your Honor. My co-counsel, Mr. Agitinat, will proceed.
Madam President, Your Excellencies, as introduced previously, my name is Mr. Agitinat, and I'll be continuing the case of the prosecution. I'll be addressing the presence of substantial ground to believe that there was war crime of intentional attack against planned protected persons, protected objects, and that of the individual criminal responsibility of Ms. Lushomo Nagala. In my first submission, I'll be proving that there is substantial ground to believe that the crime of intentional attack against planned protected persons has been committed, violating Article 28D, B, 1, 3, and 4 of the Malabo Protocol. In my first submission, it is the prosecution contention that the attack was intentional and directed against protected persons, Your Excellencies. The intentional nature of the attack can clearly be seen by the use of bird targets at the Old Town Plaza. When the armored vehicles approached the Old Town Plaza and were made by approximately 250 individuals, as seen under Agreed Facts, paragraph 21, Kidiboni Armed Forces should have disabled the system. Under Clarified Facts, paragraph 18 of the Agreed Fact, we see that bird target has trouble distinguishing between combatants and civilians in large groups and only functions efficiently when it's up to 50 individuals present. The individuals that were attacked, Your Excellencies, were civilians. They were not a member of armed forces, nor were they participating in a levée en masse. These individuals present were merely expressing their opinions, their support, and this does not in any way amount to direct participation in hostilities. Your Excellencies, clearly the civilians' act is not likely to adversely affect the military operations of Kedibonye. This is the prosecution's submission because of previous circumstances. As seen under our Agreed Facts, paragraph 20, civilians were persuaded to leave barricades peacefully previously by Kediboni Armed Forces. Therefore, the prosecution urges this honorable court to recognize that the 37 killed were protected persons and killed intentionally, therefore violating Article 28D, B1 and 4 of the Malabo Protocol. Moving on to the second part of my submission on the attack on protected persons by Adam, it is nowhere indicated in the agreed facts that the attacked persons were in any kind of activities that could possibly strip them of their status as protected persons. Therefore, prosecution will move on to proving the intentional nature of the attack. The intentional nature of the attack, Your Excellencies, can clearly be seen by the deployment and subsequent continuous use of Adam. As seen on Agreed Facts, paragraph 22, Adam was just an experimental AI program. It was never used before, and it was developed with a wide target profile and no human interference for that matter. This weapon is a weapon that is not recommended to be used by states, as seen by the 2021 ICRC's position on autonomous weapon system. On October 13, 2022, as seen on the Agreed Facts, paragraph 25, a priest, his 4 acolytes, unknown number of civilians.
Sorry, counsel, let me just stop you. You made reference to the ICRC's position, but according to what exactly? Was it an article that was published? Are there rules, regulations? What are you relying on?
In 2021, the ICRC's published published an article on their position on autonomous weapon system. And in this, they have listed autonomous weapon systems that they do not recommend states to use as a means of warfare.
What's the name of the article? Which year was it published and who's the author?
2021, and it was the ICRC's position on autonomous weapon system.
Proceed.
Thank you, Madam President. As I was saying, unknown number of local civilians and family members of the deceased Major Faustino Umbazi, they were killed in the attack. After the attack on this day, Adam should have been disabled for the reason of the belligerent party to take precaution of the choice of means and methods of attack so as to avoid excessive incidental injury and deaths of protected persons, as per Additional Protocol 1, Article 57(2)(a)(2). But as we see, this was not done so, and we see Adam commencing yet another attack on October 18, 2022, killing unknown number of patients, medical staff, therefore violating, in addition to the previous ones, also violating Article 28D, Article 28D B3 of the Malabo Protocol. Moving on to Council's submission of presence of substantial ground to believe that crimes of intentional attack against protected property was committed, violating Article 28D B10. First, the attack was directed against St. Elgius Church. This church was in the middle of providing a funeral service nonetheless, as was seen under paragraph 24 of the agreed facts. And since all churches were built in the same style, which was a domed basilica, as seen under agreed facts, paragraph 24, and UNLF fighters usually met near abandoned churches, it does not mean that St. Elgius Church was one of the abandoned churches. And in such cases, Your Honors, it should have been presumed that in not being used to contribute to the military efforts of the enemy, as per Additional Protocol 1, Article 52(3). Your Excellencies, the arguments previously forwarded in providing that the attack against protected person was intentional is also valid here. By deploying Adam, the indiscriminate attack has been accepted by the perpetrators, and that is an expression of their indirect intention to attack protected property, as established in the case of Prosecutor versus Gaelic 2006, the ICTY judgment, paragraph 132. The Mount View Sanitarium not only was a civilian object, but was also a medical unit and a historic monument. As per Additional Protocol 1, Article 53, acts of hostilities against historic monuments are expressly prohibited, Your Excellencies. And this, because of it's a medical unit, it's subject to border protection as per Additional Protocol 1 and the Geneva Conventions. As seen under agreed facts, paragraph 26, this sanitarium was being used to treat the community, the nearby community, and also UNLF fighters. The intentional nature of the attack of the sanitarium can clearly be seen by the continuous use of Adam after the commencement of the attack on the St. Elgius Church. Moving on to Council's next submission of the presence of substantial grounds to believe Ms. Lushomo Nagala is individually criminally responsible as per Article 46B of the Malabo Protocol for war crimes. Ms. Lushomo Nagala is responsible for war crimes of attacking protected persons by aiding Kediboni's armed forces by providing bird targets. Bird target was not considered a reliable and predictable autonomous weapon system that adheres to the laws of international humanitarian law, as seen on the agreed facts, paragraph 18. The issues regarding bird target shows that she was aware in the ordinary course of events that the criminal consequence, which were the attack of the civilians, which were not taking direct participation in hostilities, would occur, therefore violating Article 46B of the Malabo Protocol. Ms. Lushomo Nagala not only aided the commission of war crime, but instigated them in regards to Adam, fulfilling the mode of responsibility under Article 24 and 1 of the Malabo Protocol. As we see in paragraph 22, line 3, it was her that informed Kediboni about Adam, about the existence of Adam, therefore participating in the common plan, therefore establishing her criminal responsibility as established in the case of Prosecutor versus Lubanga 2012 judgment of the ICC, paragraph 344. It is regardless whether or not she knows when and where the crime would occur.
Counsel,
Yes, Your Excellency.
let me take you back. You mentioned instances where protected persons are protected under AHR. And you've talked also about civilian places like places like of worship or hospitals, which are also protected in the international humanitarian law. However, are there exceptions to this said protection? And do these exceptions apply in this instance where there is a church and the church is not normally used for religious purposes?
Can you clarify the question, Your Excellency?
My question is, are there any exceptions to areas that are protected against targeted attacks in instances of conflict under international humanitarian law? Places such as churches, and specifically this church in the fact pattern, which ordinarily did not have the activities of a normal church. There were no regular services that were being held. And would it fall under the state exception? You could rely on cases and laws.
Yes, Your Excellency, there is an exception. The exception is that churches that are not in active use are not protected. But as per the prosecution submission, this church is an active church, not more than active church. It was in the middle of providing a funeral service while the attack was commenced. Even if other abandoned churches were seen as being used as a meeting spot or a geographical markers to the UNF armed forces, in this case, St. Ilgius Church might not constitute. It should be the benefit of presumption as seen under Additional Protocol 1, Article 52.3. And because of this, it should have been presumed that is not in any way supporting to the efforts of another party, because it was in the middle of providing a funeral service. We cannot say for sure that this church was an abandoned church and not an active church, therefore benefiting from presumption, Your Excellency.
We may proceed.
Thank you, Your Excellency. Unless I may be of any further assistance to this court, this concludes the prosecution submissions. Thank you, Your Excellency.
Sorry, Counsel, to go back on my question, I don't believe you actually stipulated. What is the actual threshold that ensures that certain places are protected? What would make the protection be lifted according to law?
What would be, pardon Your Excellency, what would
lift the protection on a church or a hospital in instances of war or armed conflict, according to international humanitarian law? I think what I want is a direct correlation between your arguments and actually what the law says and what the thresholds are according to law.
Well, one exception that I could imagine Your Excellencies is looking for is a principle of proportionality, maybe? Or is it in regards to the presumption that is given to a place of religious institutions?
Aside from your argument on presumption, do you have any other argument that would ensure that this specific church would be protected, despite the fact that it didn't have any normal religious services going on, and it was not used in any normal religious way, aside from that specific occasion of merely being conducting a funeral service?
Well, Your Excellency, in this instance, a priest was present. His 4 acolytes were there. A funeral was taking place. This constitutes as a religious activities. Also, this church was in no way actively.
Right, would it have changed? Would your argument have changed if the attack had been carried out a day before the service, the funeral service?
No, it would, the argument would not change because as said previously, there is no way distinguishing this church specifically from other abandoned churches because we do not know St. Eligius Church for sure, as on the agreed facts indicated that this church was an abandoned church. There is no indication to it. And there is no indication in addition to that it was actively adding to the military operations, to the efforts of ULF armed forces.
Would it have, if it was stated that it was actually an abandoned church and it'd been abandoned for like a month, would it be, if it was targeted, would it change your argument then? Would it stop being a protected area?
No, Your Excellency, presumption would still prevail in this certain instances.
Much obliged, Council.
Thank you, Your Excellency.
Make your final prayers.
Well, the prosecution has concluded their submission, Your Excellency.
I'm not sure that the judges have other questions before we move on to the defense. Since there are no other questions, we can move on to the other defense's side.
May it please this court. My name is Samuel Kahura, counsel for the defense, first counsel for the defense, and my co-counsel John Chua. I'll be dealing with issue 1, which is the issue on admissibility, and issue 3, the individual criminal responsibility of Ms. Lushomo Ngala. And my co-counsel will deal with the entire of issue 2 and the prayers. If there are no questions from the bench, I wish to proceed. On the first, the defense does not challenge the jurisdiction of this court. On the first issue of the admissibility of this case in the African Court of Justice and Human Rights, I will divide my submissions as follows. I'll read Article 46H, sub-article 2A of the Malabo Protocol, which is what we rely on to say that this case is inadmissible. And it reads like this: the court shall determine that a case is inadmissible if it is being investigated or prosecuted by a state which has jurisdiction over it, unless the state is unwilling or unable to carry out investigation or prosecution. Now, Your Excellencies, I'll demonstrate that in fact, Salima was in fact investigating and has jurisdiction over this matter, and it is not unable to prosecute Ms. Lushomo Ngala. On the first issue, which is the issue of being investigated, paragraph 27 and 28 of the facts states that Salima launched an investigation into whether Asaya Roma was providing weapons to the government of Kedibonye and obtained internal Asaya Roma documents. Therefore, the first part of that provision is answered in the positive, that in fact Salima was investigating the matter. Then goes to the second part of the provision of if a state is unable or unwilling to prosecute. The issue of unwilling does not arise from the fact. The issue of inability arises that the fact that the state of Salima is unable to obtain Ms. Lushomo Ngala. And now I wish to go to the test of inability. The test for inability is provided for under Article 46, sub-article 4 of the Malabo Protocol. And the test is a total collapse or partial collapse in the justice system or unavailability in the judicial system of a way to obtain the accused. In these facts, the issue of partial total collapse does not arise. We see from the facts that Salima issues an arrest warrant, and then, as we know, an arrest warrant is issued by a judge or a magistrate and signed by the judge or the magistrate. Therefore, the judicial system is working. On the issue of being unable to obtain an inavailability in the judicial system, it does not arise because if they can issue an arrest warrant and request extradition, then it shows that the judicial system is indeed working. And therefore, Salima having investigated and not being unable or unwilling to prosecute Ms. Lushomongala makes this case inadmissible. The second part of inadmissibility that we wish to rely on is Article 46H 2D, which is the case is not of sufficient gravity. And we submit that the minor role played by Ms. Lushomongala is what does not amount further action from this court. Also, the events that Ms. Lushomongala is involved in involve limited events. The one at St. Eligius, the development of Adam and Bad Target AI and Afrop. Therefore, she's not involved in the wider war, and she's just a developer, a programmer who develops cutting-edge technology, and therefore, this case is not of sufficient gravity to warrant this court to deal with the issue. Next, I wish to proceed to issue 3, which is the individual criminal responsibility of Ms. Lushomongala.
Council,
Yes.
before you were addressing us on the issue of gravity, and
Yes.
from my knowledge, we established this through understanding whether the crimes or the scope was qualitative or quantitative. In terms of quantity, we see the number of deaths and casualties being recorded from the paragraph, from the statement of agreed facts. Now, my question to you is, don't you think the recorded number of deaths and casualties amount to a quantity that would demonstrate that indeed there was a large amount of gravity, or the case has sufficient gravity to be before this honorable court?
Much obliged, Your Excellency. On the issue of quantitative analysis, the facts, paragraph 21 states that 7 civilians were killed and 42 were injured. On the other instances, it is an unknown number, and therefore we cannot use the unknown number to quantify the deaths. Therefore, the deaths that we know that occurred are 37, and that does not meet the quantitative test to warrant action by this court. Where there are unknown number, we cannot calculate that. That cannot be included in the quantitative measure of the sufficient gravity of this case. Okay.
Sorry, Council,
Yes.
are you arguing that the death of 37 rather civilians does not amount to being a quantitative? Is that your argument? And in your definition, what is quantitative? Do you have case where to back the fact that 37 does not qualify as?
On the issue of being of the quantitative, it is the submission of the defense that the only instance that we are giving the exact number of people that died is 37. We do not dispute that there are others that died. And the 37 does not, in my humble submission, meet the quantitative test to warrant further action by this court. That can be tried by a national court, the number 37. In cases such as Rwanda.
How many innocent civilians need to die in order for it to reach your threshold of the issue being quantitative enough for it to be forwarded to this court?
Okay, on the exact number, I don't have a specific number in mind, but the cases that have been tried by the International Criminal Tribunal for the former Yugoslavia, the ICTR and the ICC are in the hundreds. And in this instance, we do not have that. So therefore,
you give us one of those cases, answer.
Prosecutor versus Al Hassan, the decision on admissibility, an ICC case. And here it involved 882 people. So therefore, you can see the difference in the number.
Which year was the matter determined?
Al Hassan, I don't have the exact citation, but it's paragraph 57 of the decision on admissibility. I don't have the year it was decided.
Counsel, what was the holding in that case?
The holding was that the matter was admissible because it involved a large number of people, and the role of Al Hassan as the commander of the default commander of the Islamic police was sufficient to warrant action by the court. If that suffices, I wish to proceed to issue 3. On issue 3, which is the individual criminal responsibility of Ms. Lushomongala, we submit that Ms. Lushomongala is not in any way individually criminally responsible for the commission of the war crimes in Missouri. And we'll all submit first on AFROPT and then on Bad Target AI and Adam. On the issue of AFROPT, Ms. Lushomongala is accused of having aided the commission of the crime by providing personal data of Assad users. This data, we submit that this data does not belong to Ms. Lushomongala because it was part of the data collected as part of the Smart City project, the Jabulani Smart City project, and that is at paragraph 10 of the facts. And even where the data of Assad users belonged to Ms. Lushomongala, the same was given by coercion. And having been coerced to do so, it therefore negates the intention. And without the intention, without the mens rea, the crime cannot be complete. Ms. Lushomongala did not intentionally aid the Kedi Bonye government by giving them data of Assad users. As according to the ICTY, an aider must intentionally provide assistance to the perpetrator with the knowledge of the perpetrator's intent to commit that crime. In this scenario, there was no intention to provide assistance to the Kedi Bonye government. Neither did Ms. Lushomongala have the knowledge that the Kedi Bonye government was going to commit the crime of unlawful confinement.
So you made reference to the ICTY.
Yes. Okay, sorry, I didn't give the case. The case is Prosecutor versus Blaskich, the trial chamber of the ICTY, number 95, 14, paragraph 285 of that judgment. Next is the issue of Bad Target AI and Adam. Your Excellencies, Article 36 of Additional Protocol 1 to the Geneva Convention states that in the study, development, acquisition, or adoption of a new weapon, means, or methods of warfare, a high contracting party is under an obligation to determine whether its employment would, in some or all circumstances, be prohibited by this protocol or by any other rule of international law. Therefore, Your Excellencies, a weapon that would be prohibited by Additional Protocol 1 or any other international law would, one, be a weapon that is indiscriminate, either indiscriminate or cannot be used in accordance with the provisions or the principles of international humanitarian law. Adam, for example, at paragraph 25, Adam carries out successful attacks on the ULF soldiers. And at paragraph 19, the use of Bad Target AI reduced the civilian casualties because he was able to distinguish between civilians and military object and the ULF fighters. Therefore, this is a weapon that ordinarily would not be restricted by Additional Protocol 1 or any other rule of international law. Therefore, if Ms. Lushomongala developed a weapon that can be used in conformity with the rules of international humanitarian law, that absolves her from the criminal responsibility because she has met the threshold of what a new weapon should be able to do.
Counsel, could you
yes.
Talk about the Adam system, specifically with reference to the principle of proportionality and distinction, and how exactly this system meets the threshold under 81?
Okay, for a weapon to be indiscriminate, to be shown to be indiscriminate, it must be shown that the weapon has never been used in a discriminate way. Let's give the example of a landmine. A landmine cannot be used indiscriminately because as long as it is set on the road, it can blow up anyone. But in this case, Adam was able to distinguish ULF fighters from civilians and was able to successfully carry out attacks. And that is paragraph 25 of the facts. Paragraph 19 then tells us.
I think you might have looked over some of the facts because according to my fact sheet, this software led to the death of a priest. Yes. And it's my understanding that a priest would be categorized as a civilian, correct?
Yes.
So okay. It actually did have civilian casualties.
On that issue, my co-counsel will present on the issue of intentional attacks, but I wish to submit that it is a priest and his 4 acolytes who died, but also an unknown number of ULF fighters died. Therefore, on the issue, on the scale of proportionality, the attack was proportional. Okay.
No,
Then-
Council,
Yes.
just follow up to that question. My knowledge also from the statement of facts is that Ms. Lucia Mongala knew that this software add-on was defective. How then do you argue that?
On the knowledge that Adam was defective, Ms. Lucia Mongala instructed the software engineers to patch the Adam software to ensure that it does not target civilian objectives over military objectives. This clearly shows that she had the goodwill and the intention to avoid civilian casualties. That goes to her defense to show that, in fact, she was careful. She took the precaution to ensure that this weapon does not attack civilians. If that suffices, then I wish to rest my case and cede the floor to my co-counsel.
Counsel, sorry, before you cede the floor to your co-counsel, on the issue of admissibility, was your argument that Bukada was unwilling and unable?
No.
Or was it that it was willing and able to prosecute Ms. Ndala?
Oh. First of all, there are three countries here: Salima, Kedibonye, and Bukada. Salima, Bukada is not a state party to the Malabo Protocol. Therefore, the obligations under the Malabo Protocol do not apply to Bukada. It applies to Salima. If Salima was investigating and was unable to prosecute, that is where that inadmissibility test proceeds from. Therefore, I've demonstrated that Salima was investigating and was not unable to prosecute Ms. Lucia Mongala. Therefore, this case should not be admissible before the African Court of Justice and Human Rights.
But there's an issue of unwillingness and inability. So if it is able but unwilling, then the court,
Yes.
the matter is admissible, correct?
Sorry, I've not heard the last part.
If a state is willing, or rather
Yes.
able but
Yes.
unwilling,
Yes.
then this honorable court has, like it's you have jurisdiction and the case is admissible before this court, correct?
Okay, the test for unwillingness is provided for under Article 46H3, and it is that the proceedings were either being undertaken or a national decision was being made for the purpose of shielding that person. That does not arise from the facts. The second being there is an unjustified delay in the proceedings, and that does not arise because there are no proceedings in this fact.
But Salima take any active measures to ensure that prosecution was actually done against Ms. Ndala?
Sorry?
Can you pinpoint from the fact sheet the measures that Salima actually undertook to prosecute Ms. Ndala?
That Salima had?
Is there evidence from the fact sheet that Salima undertook any measures to prosecute Ms. Ndala?
Yes. They issued an arrest warrant to against Ms. Lucia Mongala for illegal weapons transferred to Kedibonye, and even requested for extradition of Ms. Lucia Mongala for purposes of proceedings. And even in the office of the prosecutor, they stated that in the absence of Ms. Lucia Mongala, they could not start national criminal proceedings against her. Therefore, it shows that they were, in fact, all through willing to prosecute Ms. Lucia Mongala.
But the prosecution was not initiated.
Was?
In the absence of active prosecution, then is the matter admissible before this court?
There may be if there's a prosecution going on, then the matter is inadmissible. But in these facts, there's no prosecution going on. So they're inadmissible. Yes.
Okay. Thank you, Counsel.
Much obliged,
Counsel, just before you conclude your submission, I believe you're submitting that this court indeed has jurisdiction, but the case is not admissible. Is that right? All right. Now, which criteria do you use to establish this jurisdiction, even though you've conceded to the prosecution's argument on the basis of jurisdiction. We understand that jurisdiction can be temporal, territorial, personal, and the criteria is wide. Guide this honorable court on the matter of the jurisdiction, this honorable court.
On the issue of jurisdiction, we concede that, in fact, this court has jurisdiction because Article 46E, which is the preconditions to the exercise of jurisdiction, state that extraterritorial acts by non-national which threaten a vital interest of that state make the claim this court to have jurisdiction. And Salima has a vital interest in Uzuri, and therefore they can submit this matter to this court. Therefore, the matter is admissible. And under 46F, the excess of jurisdiction, a situation which one or more such crimes appears to have been committed is referred to the prosecutor, or the prosecutor has initiated an investigation, which does not apply here. But in this fact, a situation in which one or more such crimes appears to have been committed is referred to a prosecutor by a state party. Salima is a state party to the Malabo Protocol and has referred this situation to the office of the prosecutor. Therefore, under Article 46F of the Malabo Protocol, this court has jurisdiction to handle this matter. If that suffices, Your Excellency, I wish to cede the floor to my co-counsel.
You may, I think we can have the second speaker.
May it please this honorable court. My name is Chua Nyamari. I'm the second counsel for the defense. I'll use 15 minutes of this court's allocated time to deal with issue number 2, that is on whether there are substantial grounds to believe that there are crime of unlawful confinement, intentional attacks against plant protected persons, and attacks against protected property were committed in Uzuri. And if that suffices, I wish to proceed. Thank you. The defense, in response to the submissions made by the prosecution, submit that the core crimes of unlawful confinement, intentional attacks against plant protected persons, and attacks against protected property were not committed in Uzuri. Your Excellency, I will begin with unlawful confinement. Your Excellency, the crime of unlawful confinement can only occur, that is in situations where there is either an international or an international armed conflict. Your Excellency, the defense wished to submit that there was in fact no armed conflict in this particular matter. The test for determining the existence of an armed conflict was set out in the case of prosecutor against Sadiq. This is an ICTY decision case of 1995, which averred that an armed conflict exists whenever there is a resort to armed force between states or protracted armed violence between governmental authorities and organized armed groups or such groups within a state. Your Excellency, going by this rationale that was provided in the case of prosecutor against Sadiq, the events that led to the detentions were not in the context of an armed conflict. Your Excellency, paragraph 8 of the statement of the agreed facts clearly states that the unintentional death of Mr. Mahdi Saiko is the one that caused the widespread upheaval which led to Uzuri residents protesting and occupying government offices. Your Excellency, it is also worth noting that the chase on Mr. Mahdi Saiko was not for graffitiing pro-ULF slogans, but it was because he was doing so that is on public property. Your Excellency, is provided for under paragraph 7 of the statement of facts. Your Excellency, or rather paragraph 8, sorry for that. Paragraph 8 further states that incontrovertibly states that the riots and occupation of the local government buildings were in response to a mass rally that were commemorating Mahdi Saiko's death. Your Excellency, it is therefore our submission that there was in fact no armed conflict between rather what was there, it was a situation of internal disturbances. Your Excellency, we also wish to submit that in the alternative, if these honorable courts deliberates and concludes that in fact there existed an armed conflict, or rather an international armed conflict, the defense submits that the confinement of civilians during an armed conflict can only be permissible in limited situations, but will be unlawful if the detaining power does not comply with the provisions of Article 42 of the Geneva Convention, Your Excellency.
Sorry, Council. Sorry, Judge. I want to seek clarification. Are you arguing that there is no armed conflict or there's no international armed conflict? Are you saying there's an armed conflict, but it's not international? Or are you saying there's no conflict at all?
Your Excellency, I wish to submit that from my first argument, I argue that there was in fact no armed conflict, either that is of either an international or non-international. But if this court deliberates and concludes that there existed an international armed conflict between the ULF and the state of Kedibonye, we submit that the confinement may be unlawful in situations where the state does not comply with Article 42 of the Geneva Convention. Your Excellency, in the circumstances, I wish to, yes, Your Excellency.
Just a follow-up question from the President of the Court. If I well appreciate your position that your argument is that it was just an internal disturbance.
Yes, Your Excellency.
However, you are also trying to make an alternative argument that if this honorable court then comes to a determination that there was an international armed conflict.
Yes.
What makes you have that alternative argument and want to preempt that the court will actually hold a determination that it was an international armed conflict and not a non-international armed conflict? What makes you make that position?
Your Excellency, the situation in Uzuri was between the ULF soldiers and the Kedibonye forces. Your Excellency, in that situation where there is a conflict, there is an armed conflict between an organization, or rather army, with a state, that amounts to an international armed conflict. Your Excellency, that is where I'm basing my argument, that in the case where this court may find that there existed a fight between the ULF and the state of Kedibonye, then they have to adhere to Article 42 of the Geneva Convention, the fourth Geneva Convention.
Sorry, Council, are you saying there's no conflict between the ULF and the state of Kedibonye?
Your Excellency, maybe if I can repeat myself, in the deliberation of this court, if it finds that there existed an international armed conflict on the basis that the ULF and the Kedibonye forces were in fight, then that amounts to an international armed conflict. And it therefore rises that they have to adhere to Article 42 of the Geneva Convention. Your Excellency, I am not sure if I answered your question.
You can proceed.
All right, thank you, Your Excellency. Your Excellency, Article 42 says that the internment or placing in assigned residence of protected person may be ordered only if the security of the detaining power makes it absolutely necessary. Your Excellency, the first instance to demonstrate that the security of Kedibonye was in jeopardy if the civilians were not interned is that the ULF sympathizers were using Asadat to organize protests against the Kedibonye and act of resistance against the Kedibonye forces. Your Excellency, this is pursuant to paragraph 9 of the Statement of Facts. Your Excellency, the next requirement for detention to be lawful is a procedural requirement that is contained under Article 43 of the Fourth Geneva Convention, which states that any protected person interned or placed in assigned residence shall be entitled to have such action reconsidered as soon as possible by an appropriate court or administrative board designated by the detaining power. Your Excellency, in Uzuri, within 3 months, the government would consider whether or not the restraint imposed on a person will continue or it will be put to a halt. Your Excellency, the Uzuri law provides for administrative district courts, the Court of Appeal, and even the Supreme Court to appeal on the issues of law. Your Excellency, is provided for under paragraph 15 of the Statement of Facts. Your Excellency, it is a clear manifestation that the article. Yes, Your Excellency.
Just to try to appreciate your submission. Huh?
Yes.
I'm just trying to imagine a scenario whereby once the bench retires to make their finding, they conclude that indeed they agree with your submission that it was a just internal disturbance.
Yes, Your Excellency.
Now, if an event that the bench holds such, do you think the Geneva Convention will really be applicable in these circumstances? In an event that the bench holds internal disturbance?
Your Excellency, I wish to submit that it will not be applicable in this particular matter. Your Excellency, the Geneva Convention, it's only limited to situation where there is either an armed conflict that is of an international character or non-international character. Your Excellency, if it is a matter of internal disturbances, then the Geneva Convention is not applicable in this particular matter.
And to add to my co-judge's question, in that event, will this court have jurisdiction?
Your Excellency, come again, Your Excellency.
In the event that it's an internal matter, will this court have jurisdiction over the issue?
Your Excellency, I wish to submit that in that particular matter, this court will have no jurisdiction because the only way in which this court will have jurisdiction if, as my co-counsel stated, that there is extraterritorial acts by an national, which in this particular matter will affect the vital interests of that state. Your Excellency, if it is a matter of internal disturbances, then we submit that there will be no, this court will have no jurisdiction to hear this particular matter.
And we're relying on what article?
Your Excellency, as my co-counsel, we ride on Article 46E, that is bis, which provides the condition for the exercise of jurisdiction by this court.
Counsel, your co-counsel did not make any reservation or any counter argument. He actually upheld fully that this court has jurisdiction. And then again, you are having an argument that the court should be of the opinion that the conflict is just an internal disturbance. And then again, you're also informing the court that then this court will not have any jurisdiction. So it really kind of bit confuses the bench then who to believe. Is it your co-counsel or is it your position? Because your co-counsel, when he was establishing jurisdiction, from this court, actually you're blind to the submission of the prosecution that this court has, absolute jurisdiction. So now it's still a bit confused the bench, but I don't know how you intend to direct the bench.
Your Excellency, I also submitted on the alternative. That is in case of where this court will find that there was in fact an international armed conflict. Your Excellency, if you are going to rely on the second bit of it, then we rely on Article 46E, that is on where my co-counsel submitted that this court will have jurisdiction. Your Excellency, if you come to a conclusion that there was in fact no internal, it was an internal disturbance, then we wish to submit that the court will not be having jurisdiction to hear this matter.
Counsel, just to follow up on that, we find the office occupying Uzuri. Don't you think that now would amount to international armed conflict, the presence of the Kedibonye?
Sorry?
From the statement of fact, we find the Kedibonye forces occupying Uzuri. Wouldn't that then amount to international armed conflict, their presence in Uzuri, or their occupation?
Thank you for your question, Your Excellency. Your Excellency, it will only amount to an armed conflict if there is a protracted armed violence by the ULF, or rather the ULF reacts to such occupation, and they react by fighting back to such intrusion. Your Excellency, in that particular case, if the Kedibonye forces intrudes and maybe the ULF soldiers fight back, then it will result to an international armed conflict. Your Excellency, now if Salima soldiers react to such intrusion, then it means that there will be an international armed conflict because it is a protracted violence between a state and a state. Your Excellency, in that particular case, we wish to submit that by the fact that Kedibonyi forces intruded, or rather invaded into Zuri, and the ULF were fighting back, that now resort to an international armed conflict. Thank you, Your Excellency. Now on the issue whether there was substantial grounds to believe that the crime of attacks on protected property was committed in Zuri, we submit that this crime was not committed. Your Excellency, Article 53 of the 4th Geneva Convention states that, and I read in verbatim, any destruction by the occupying power of real or personal property belonging individually or collectively to private persons or to states or public authority or to collectively to or to social or cooperative organization is prohibited, except where such destruction is rendered absolutely necessary by the military operation. Your Excellency, Article 53 of the Additional Protocol 1 further provides that it is prohibited to commit any act of hostility against historical monuments, work of arts, and places of worship, or rather to use such objects as support of military efforts, or make such objects the object of reprisals. Your Excellency, I wish also to rely on Article 28D, Part 4, which prohibits intentionally directing attacks against buildings dedicated to religion, education, art, and historical monuments, or collectively provided they are not military objective. Your Excellency, from the above provisions, one thing that stands out is that the drawback clause is that it is prohibited except where such destruction is rendered necessary, absolutely necessary by the military.
The oralist time is up.
Your Excellency, with your permission, I wish to request for only 3 minutes to make my final conclusions.
You can have 1 minute to consult with the prayers.
Your Excellency, I have not heard you quite well.
I have 1 more minute to finalize.
Thank you, Your Excellency. Your Excellency, the attacks on protected property is prohibited only unless there is a cause to show that it is of military objective. Your Excellency, the fact that the sanatorium north of Jabilani was used to store ammunition, this rather makes it a military objective, and it is of necessity if in the advantage of the ULF protester soldiers to attack it, because it is of great advantage and it will help in weakening the adversary. Your Excellency, since I have just 1 minute, I wish to make my my prayers before this court. Your Excellency, the defense wishes to submit that the crimes of unlawful confinement, the crimes of attacks against protected property and persons were not committed in Zuri, and that this particular case is admissible. And as you retire to your chambers to deliberate on this issue, we wish to pray that the African Court of Justice has jurisdiction of prerequisites that they have been met, and that the case against Ms. Lushomo Ngala in this particular case is inadmissible. The crimes of intentional attacks against plant protected persons, protected property, and unlawful confinement were not committed in Zuri. And if that suffices, I wish to rest my case.
I believe you are the first speaker on the defense side.
Yes. No, I was the first speaker on the prosecution side.
Oh. You may have your rebuttal.
Yes. As Your Excellencies may recall, my name is Quater, and I will be presenting the rebuttal for the prosecution. The first point of rebuttal is that the defense contends that this court does not have jurisdiction as it does not fulfill any of the requirements under Article 46E of the Malabo Protocol. We contend, and as we've previously seen, that only one of the conditions of Article 46E of the Malabo Protocol must be fulfilled. And indeed, it has. One of those that we contend has been fulfilled is that the war crimes, the alleged crimes, must have been committed in the territory of a signatory. As we have said earlier, Yuzuri, as we have established earlier, Yuzuri is the territory of Salima. And the alleged war crimes have been committed in Salima territory because they were committed in Yuzuri, and one of those requirements therefore has been fulfilled since Salima is a signatory to the Malabo Protocol. The other is regarding the admissibility. Now, the defense has contended that this court does not, it wouldn't be appropriate for this court to review the case because Salima was able and willing to investigate the matter. However, we contend that Salima was indeed unable, even though it was willing to deal with the case. This can be established in the fact that it was unable to get hold of Ms. Lushomo as Bukada refused to extradite her to Salima. And the other is its inability to investigate and deal with the matter prudently, because it is in an armed conflict. It is in a brutal armed conflict with its neighbor Kedibonye, and cannot reasonably be expected to prosecute a person implicated in that war. And of course, it wouldn't be able to prosecute because it couldn't get a hold of Ms. Lushomo. The next submission as regards this rebuttal is that previously the defense has submitted that Ms. Lushomo and Kedibonye had business dealings, and their relationship ended there, and that Ms. Lushomo does not have sufficient belligerent nexus to be considered as a war criminal. However, we contend that there was sustained correspondence between Kedibonye and the Asahi Roma executives, especially, of course, Ms. Lushomo, as they were not involved not once, twice, but 3 times in providing these weapons and softwares. First of all, it was abrupt. We saw that under the facts of the case that Kedibonye approached Ms. Lushomo, and the second time also that Kedibonye approached Ms. Lushomo. However, in the third time, Ms. Lushomo herself approached and offered as Adam. And of course, the development and the use stages of these weapons is, the line is blurred. Therefore, without having belligerent nexus, these weapons could not be operated. Therefore, it cannot be said that Ms. Lushomo does not have belligerent nexus. She was a mere weapon supplier. The other submission as regards admissibility again is that the defense contended that this case was not of sufficient gravity because there were only 37 individuals killed. However, we contend that an unknown number of civilians had been killed by the use of bird target and Adam. Also, it should not be the number that matters. Of course, there is no number under international humanitarian law, under the Malabo Protocol, or other legislations, that there must be a certain set number that
President.
Yes. May I request the court for 2 additional minutes?
Or you can have 1 minute. Please continue.
Much obliged. The third submission is regarding the unlawful confinement. It was the defense's contention that Ms. Lushomo was forced to supply data to the Kedibonye government, and that this amounts to her absence of intention in committing these acts. However, we would like to reiterate that the commission of the crime did not involve the supply of data alone, but the supply of abrupt as regards the unlawful confinement. Ms. Lushomo was at liberty to either deny access or grant access to abrupt. She, of course, did the latter, and therefore her intention has been established. The third is that there was indeed an international armed conflict when the purported war crimes had been committed. Of course, this can be seen in the fact that the Yuzuri Liberation Front conducted its operations with sufficient intensity and organization. It was stationed in the northern area of Yuzuri in the mountains. Much obliged. This concludes my rebuttal.
Sorry, Button?
Much obliged, Your Excellencies. I'll be doing the rebuttal for the defense. And the first point of rebuttal I wish to submit is that Uzuri, first of all, is not part of Salima. In 1975, Kedibonyi took over, and there was military occupation from 1975 to 2000. Therefore, Uzuri is not part of Salima, and even Kedibonyi is the power that gives Uzuri the power to administer themselves. The second point of rebuttal is that the prosecution submitted that Bukada was unable to prosecute the defendant or was unwilling, and that was their first submission. In the rebuttal, we see a shifting of the goalpost to Salima. Bukada is not party to the Malabo Protocol, and therefore the prosecution should stick their submission that they submitted that it was Bukada, and they should stick to that submission. That submission is that the prosecution submits that Salima was unable to extradite. 2 days after the extradition request was refused is when Salima referred this matter to the prosecutor. Therefore, there was not even an attempt for diplomatic negotiations for the extradition of Ms. Lushomongala. And that point is that is the issue of quantitative and qualitative analysis. Where there is an unknown number, yes.
Sorry, counsel, I know it's your rebuttal, but let me just seek clarity. Are you saying that they should have negotiated in order for them to be able to obtain the physical custody of Ms. Ngala?
Being the fact that illegal weapons transfer is not a recognized crime under the Geneva Conventions or the Malabo Protocol, that makes the issue of universal jurisdiction to not exist. Therefore, that principle of haute de rere or judicare does not apply here. You have to negotiate extradition of Ms. Lushomongala because this is not a crime that makes Bukada or falls that obligation falls on Bukada to either prosecute or extradite. This you have to either request extradition, but you cannot request prosecution because it is not recognized as a war crime under the Geneva Conventions or the Malabo Protocol. And the last point is that on the issue of unlawful confinement, we submit that the prosecution submits that there was international armed conflict or non-international armed conflict, I'm not sure, but we submit that there must be a nexus between that armed conflict and the unlawful confinement. With that, I wish to rest my case, Your Excellency.
Do any of the judges have questions for the speaker?
None from me.
Mr. Patrick, might you have questions for the speaker?
Not at all, Madam President.
Okay, then I guess this concludes the session.
Madam President, the court is now adjourned. Participants, you can wait into the courtroom as the judges go to the deliberation room to deliberate. Okay, so we have the judges back in the courtroom. Right now, the judges will just be able to give you feedback in terms of the round. And then, of course, at the end, Madam President will be able to declare the winner of the round. And as you know, as per the rules, the winner of the round proceeds directly into the semifinals. Madam President, over to you.
I'd like to start by saying congratulations to each and every one of you. You guys have done a good job. You'll be able to get here. So we're going to, I think we can begin with introductions. The judges are going to introduce themselves, and then immediately after, they're going to give their comments. So, Farida.
Thank you, Madam President. Hi, everyone. My name is Farida Bundi, and I am an advocate of the High Court of Kenya. And I'm glad to see you all, some for the first time and some I've met before. And mooting is always an experience, either as a contestant, even for us as judges. And we know the amount of sacrifice, the hard work, the research, the courage to even speak in front of people, and all the effort it takes to participate. So mine is to congratulate all of you for coming this far. Making it to the quarterfinals is not a joke. Taking your time to read, understand the facts, do your research. I know it takes a lot. And I'm happy to be part of this project. Just a few pointers to our participants generally is to continue with the coherence and the consistency when you're arguing. Make sure you're relating the facts of the case to whatever case law that you have and whatever statute that you're relying on. That flow is very important to us as judges, and also for you to help you understand your case better and argue even better. We agree and we understand that this comes with time, this comes with experience. So keep polishing up your arguments, and congratulations once again. Thank you, Madam President. Over to you.
Mr. Patrick.
Thank you very much, Madam President. My name is Patrick Mwema Mumo. Of course, an advocate, High Court of Rwanda, and also of Kenya, and also the regional coordinator, that is for Tanzania, Rwanda, and Kenya, for Fidel's Integrated Services Limited. And of course, I also hold Master of Laws, specialized in public international law, and therefore this is an area that I'm very much well acquainted with. I just want to appreciate the both teams for your good presentation. As my colleague judge has alluded, it's not easy, you know, to make such awesome submissions, you know, even having that guts even to decide to participate in such a competition. Of course, I've participated in, you know, in moot, so I understand, you know, the pressure that, you know, it comes with, even for the coaches, you know, the pressure that it comes with. So mine is just to say thank you for you guys showing the ability, and I know in future will, you know, make good officers of the court. Just a general comment for the team that will be progressing. You know, it's important. One, as a team, you need to have, you know, teamwork is quite very important. You know, before you decide to appear before any bench, ensure that you have consulted your colleague very well so that you don't have divergent arguments, you know, as you're making your case. Again, also, this is something to always continue repeating, but I think also how you present, you know, your case in court matters a lot. You may fail to have the content, but the confidence that you have, you know, it matters a lot on how you are even addressing the bench is quite very important. And therefore, also the decorum, you know, how, again, you're also appearing is very important. And then again, also the language that you're using, you know, to the bench, I also believe it's quite also very important. Then again, it's always very embarrassing, you know, as a litigant when the bench is asking you for citation of the case that you're present before the court. Always when you're making or when you're citing or you're making reference to any case, it's always very important at the first instance, to make a full citation of that particular case. And again, I also say go an extra mile and even provide the specific paragraph that you're making reference to. That makes the work of the bench very easier. And if at all you would wish or you rely that particular authority in your subsequent submissions, it's always very important then, to enable the bench to be aware that thereafter you'll be able to refer this case in a so manner. So I think that is an area that I believe the teams need to really improve. Then again, when you're making an argument and you really want to convince the bench to buy your argument, it's always important to have an authority that is supporting your point of argument. It's something that adds a lot of weight in persuading the court in buying a submission. So I think generally these are just some of the observations that I've observed, and I believe they will help you moving forward. Otherwise, thank you very much, and may God bless you. Back to you, Madam President.
Thank you to my four judges. My remarks with regard to how the team have performed, I think I'll categorize this into two. I'll start with the prosecution and then I'll go to the defense, and then we will give, I will communicate our deliberations. So with regard to the prosecution, you put up a very strong case. And we were impressed by the fact that you were able to have a nice understanding of both the facts and the law. And also we were impressed by the fact that you were able to answer questions, not only relying on specific paragraphs of the fact sheet, but also quoting sections of the law and using case law to buttress your arguments. So kudos to you on that. What I would recommend is for you to build on maybe the last two issues. It's always good to have do as much research as you can, build on your case law, build up on say articles, especially I think I'll echo what my co-judges have just said. So if you're going to rely on something, if it's a commentary, cite the entire commentary. Do not wait for the court to ask you, where exactly are you getting this information from? It's always good as a rule of thumb, it's always good, especially when you're doing moves, to speak with authority. Just don't make arguments, but base them on something that will help you communicate better and will earn you points. So do more research. More research is always good, especially on some of the areas that you probably ask you questions on and you think you might not have had ready answers. Do more research, find more cases, it's always good. And also when you're relying on certain instruments, you can maybe inform the court, are these instruments binding or are they merely persuasive? With regard to the defense side, you also have done a good job. However, I think by the bench asking you questions, you are able to decipher the fact that maybe both of the speakers trained differently. There wasn't teamwork from your team based on the way the submissions were being made, because one person would argue A and someone would come, the next person would argue something totally different. So when you're meeting, there has to be coherence. I know sometimes you might have different personalities because we are different people, but when it comes to making an argument before court, you and your co-counsel have to be on one accord. You need to know these are the issues that we're going to address, these are the arguments, and this is what we're sticking with. You might have a crazy argument, but if you're able to substantiate that argument, you might be able to actually sway the bench. So I would say there's the need for you to improve on your knowledge of the facts, especially because sometimes when questions were being asked, some of the speakers were unable to pinpoint exactly what part of the fact sheet you are relying on, or even rely on actual information that had been provided in the fact sheet. So there needs to be improvement on knowledge of the facts as well as knowledge of the law. It's always good to have case law. It's always good to have reliable sources, instruments, laws, you name it. Research, I think, is the core of the need for competitions and also actual practice, if that is what you want to do in your future. So I would like to congratulate everyone for getting to this point. And
President, so before you announce the results, I would request the participants to on their cameras.
Mr. Quater. Mr. Chair, could you please turn on your camera?
I think he has been disconnected.
Sorry. Judge President, we are on attachment, so I think maybe he's been called or something. He maybe not been in his computer.
Okay, Ahmed, I hope it's okay. At least there's a representative from their team.
Yes.
Okay. Apologies. I was supposed to introduce myself. My name is Doris Kennedy. I am an advocate of the High Court of Kenya. I am currently practicing law in Kenya, and I am also an international law and human rights consultant. With that said, it was a delight to have both of you teams, both of these teams rather, argue before us. Some of you have appeared before me on the other side, and some of you haven't. And I think we've noted a sense of improvement, and we've noted the fact that you've actually taken some of our comments we have and actually put more work in your submissions. So our deliberations were fruitful and our decision is quite unanimous. So the team that will be proceeding to the next round is the prosecution team, which comprises of Quater and Mr. Getnet. Congratulations. All the best for the next round. For the other team, for the defense team, you should not be discouraged. The fact that you were able to carry out good research and come and make your submissions before us means that you actually have this improves your interest in this area of law. And I hope that some of the information that you've obtained from your research can be directed towards maybe publishing something. So congratulations also for you for being able to have this opportunity to go against other teams. All the best to everyone. Thank you for your time.
Thank you, Madam President. To the judges, we appreciate your time and your comments to the participants. I'm sure they have got remarks that will be helpful for them. To the participants, I'm sure you have received the comments, and you have a task in terms of utilizing those comments in your future. For us, it's not just about the competition, it's about also a learning process the networking. So of course, it's a competition. We must have a winner irrespective of the situation. But at the end of it all, I'm sure you have learned one more thing in this whole process. On behalf of FIS, we'd like to say our gratitude to the judges and to the participants. And for the team that is proceeding to the semifinals, we'll be able to communicate regarding the schedule of the semifinals once all the teams have finished competing in the quarterfinals. Otherwise, thank you very much.